Hi, my name is Jason Tweed. I'm Senior Partner at MediaStead, a digital marketing agency in Pennsylvania. Today we're going to be discussing best practices in website privacy, specifically how to develop privacy policies and procedures for small business websites. First of all, why is it important to have a good privacy policy? Well, first of all, there are two new laws in California and in the European Union that require that you manage privacy on behalf of the data that you collect on individuals. These new laws are becoming the de facto standards industry-wide. You also may be required to make additional compliance through HIPAA if you're managing health information, or through PCI compliance if you manage credit card information. Inevitably, there will be other laws in other states and other countries. By preempting this and abiding by the California and European standards, you're more likely to not have a problem with your own state laws in the future. Lastly, consumer confidence is really what's driving these privacy issues. People are nervous about privacy breaches, and today the web contains much more information about us as individuals than it ever has before. Demonstrating that you abide by privacy standards goes a long way toward instilling confidence. There's also both criminal risk and civil liability that you want to mitigate because they can be substantial. We'll talk more about that in a future slide. So what are the laws? In the European Union, the law is known as the GDPR, or General Data Protection Regulation. It came into effect in May of last year. It applies to all companies doing business in the EU, both large and small. It has strict compliance protocols and substantial penalties for non-compliance. The California Consumer Privacy Act just was passed and comes into effect January 1st, 2020. It applies to all residents of California, regardless of their location or of the location of the transaction. So if you do business with California residents, you are required to abide by this Privacy Act. It highly values consumer protection, and it also has governmental and civil penalties that can be assigned. What is considered personal data? Well, it can be a variety of things. Obviously, name, address, phone number, and email are something that's collected on many websites. Other websites collect social security numbers, driver's license numbers, passport numbers, etc. Any information that's personally identifiable, such as your age, gender, ethnicity, religion, or the location of you when you get involved in a transaction. That could be either your physical location, the GPS from your phone, or your IP address from your web browser. An interesting thing is that usernames and pseudonyms are also protected. It's ironic because literally you're allowed to give misinformation and false names and yet that data is still protected. So what do we mean when we say what rights are protected? First of all is transparency. The European Union law requires you to tell us what data you collect and how you intend on using it. Simplicity. The policies must be written in clear, understandable English or in the native language of your website. The EU specifically has outlined that you must not be they must not be filled with legalese. The right to access applies in both laws, and that says if you have information about me, you have to give me that information if I request it. The right to rectification is for the European Union only, but if you have data about me that's incorrect, then I have the right to correct that information. The right to be forgotten. Essentially, you're allowed to request that a website deletes your data and removes it from their system. The right to limit processing and portability. This is a little more complex. Processing is when a computer algorithm makes a decision about you based on the information they've collected. You have the right to opt out of that processing. For example, if you fill out an application and then you are denied a loan, you have the right to have a human being reprocess that application. Portability says if you have information about me and I want that information transferred to another company to process, then you have to abide by that. That's primarily used in financial considerations. For example, if you're switching from one bank to another and your banking records need to transfer over, that would be an example. We don't quite know how this is going to act in practice. So that's one of the issues. The GDPR has one big problem. It applies to all businesses, large and small. However, the maximum fines are 4% of global revenue, or 20 million euros, whichever is greater. The fines for privacy breaches are different than the fines for non-compliance. However, the non-compliance can still be 2% of global revenue. Additionally, member states are permitted to penalize companies individually or in addition to the EU penalties. The California law is better written in this regard. It only applies to businesses over $25 million or 50,000 users. The penalties, however, are on a per-user basis and can range from $2,500 to $7,500. It's important to note here that your liability is only for California users. Civil liability can also be imposed. For example, if you have a data breach, the state is allowed to say that you owe a penalty to the people who you've hurt by breaching their data. Those penalties can range from $100 to $750 per person. If you are damaged by more than $750, you're also eligible to sue independently, and that right is protected under the California law. It's hard to determine how the GDPR is going to be enforced, it appears as though the GDPR is only going to be enforced on large companies. However, technically, every company needs to be compliant. So we will have to see if the GDPR is used to prosecute small companies. Additionally, they may refer that to the member states. So, for example, if an individual country wants to pose a different penalty, they are going to be able to do that regardless of whether or not the European Union puts on its own penalties. Part of the GDPR is that you have to identify a data protection officer. This can be an individual or an organization that is responsible for data collection, storage, and use. The data protection officer must be knowledgeable and qualified regarding how you collect, secure, and store information. They must be publicly identified with contact information. They must report directly to a senior level manager, and they also have to have the ability to access, update, and remove personal data. The responsibilities of your DPO, first and foremost, is to respond to requests for information from individuals. If someone inquires and would like to have a copy of all the data that you have, or if they would like to have all of their data removed, you have 72 hours to respond to that. That's true in either the GDPR or the CCPA. Within the CCPA, you have up to 30 days to rectify that request if you aren't able to comply before there will be any penalties. It's also your responsibility to identify and assess security breaches. And if you're in the European Union or do a lot of business with European clients, you also have to report those security breaches to the Data Processing Authority, which is the organization that oversees the GDPR. You have to disclose that security breach to consumers within 72 hours, and you have to give them specific actions if necessary. You also are required to cooperate with law enforcement if the criminal breach is deemed, or if the security breach is deemed of a criminal nature, such as data theft. Lastly, it's the DPO's responsibility, if they identify gaps in security, to rectify them. This is one of the reasons they are required to report to the top management, is because they want to be sure that the DPO is giving that information to top level managers, so they cannot hide behind, I didn't know that was an underling's responsibility. A few words of wisdom. Transparency is paramount. The object of this is to be more transparent with how you collect and store and use data. It's important particularly because the driving forces behind these laws are not business interests. They are the demand of the consumers to have their privacy protected after a number of breaches that were major and were public. Data collection and processing is useful to your customers but it deserves respect. The more information you collect about the visitors to your website, the more potential value you can create for those visitors. However, you have an obligation to treat that data with respect. In terms of small business, one of your main objectives should be to transfer liability wherever possible. Frequently, you'll use software from a third-party company in the process of collection or processing that data. Wherever you can, you want to identify that third-party company and refer people to their privacy policy. That way, organizations such as Google that manages Google Analytics carry much of the burden for the information that's collected through your analytics data. Prevention always beats rectification. Simply said, preventing a security breach is always to your benefit rather than managing it after the fact. Be good stewards of the internet. The better we treat our clients and our customers as business owners and website owners, the more likely we are to have fewer laws and less regulation, and also encourage business and encourage our customers to choose us. Thank you for your time. I'm Jason Tweed, Senior Partner at MediaStead. You can learn more at www.mediastead.com or reach out to me directly if you have a specific need. Thank you.